Ladies and gentlemen, welcome to the Quest webinar where we're going to be discussing the equal treatment and equal pay for work of equal value. As we start this webinar, I just want to let you know that our presenter will be John Botha. I will give you information about him at a later stage. The webinar is scheduled to be for an hour, but we believe that it may be a little bit lesser than that. In terms of how we're going to proceed, if you have any question, please type it in the box, the question box. We will consolidate the questions and we will deal with them at the end of the presentations. If we are not able to deal with all the questions, we will consolidate them and we will answer them individually at a later stage. This webinar is being recorded, so it will be made available on our website at a later stage today. In terms of proceedings, I would like to tell you about Quest. We as an organization have got few services that we provide. I'm going to start right from the top, field marketing. Our field marketing is a service that we provide agents on the field to either collect or disseminate information or messages to a target audience of the client. As an example, we do store audits, we do promoters, we do merchandisers, depending on what the client is requiring. If we move clockwise, managed service provider. This is where we manage all your staffing service providers through a VMS solution. In other words, you are able to get one report from us as a service provider, as well as the ability to manage all the SLAs that you have with those service providers. The outsourced staffing solution is the traditional model where we have people that are contracted to you as a client from as little as 1 day to indefinite, depending on what you are looking for. Permanent placement solutions, self-explanatory. The recruitment process outsourcing. The clients have the ability to outsource a portion or part of their recruitment process or the whole of the recruitment process. So as an example, you may choose to outsource response handling to us, or you may choose to outsource a longer process in the recruitment process outsourcing. The specialized staffing project, this is where the clients may require to have employees to work on short projects, such as capturing data into a system, updating company information, updating client information that is captured on a particular system. We are able to employ those people, deploy them to work on that system, and they get based on our site. Having said that, I would like to introduce our speaker for today, John Botha. So John is currently a managing partner, strategic solutions at Adcock Holdings, a business unit SA member, Nedlac Labour Market Chamber, executive member, the Confederation of Association in the Private Employment Sector, CAPES. He's previously been a Commissioner of Employment Equity Commission, a Commissioner in Essential Service Commission, Business Representative of the ILO Geneva ILC, Managing Director of Zin and Consulting, Managing Director, Global Business Solutions. I'm going to hand over to John.
Thank you very much, Casey. And it's a privilege to be here, colleagues, to spend this time with you this morning. The topic, as Casey says, has got to do with the whole matter of equal treatment and equal pay for work of equal value. I'm sure that you've heard different terms being thrown around, but Those are the two terms that are used in the LRA and the Employment Equity Act respectively. But before I delve into this particular slide in front of you, I just want to make a few comments. The first comment I want to make is that we seem to adopt the policy in South Africa that if it moves, it needs to be regulated. And we find ourselves in the human resources space with labor law that literally regulates everything from cradle to grave. We have regulation of recruitment methodologies and processes. We have regulations of skills development. We have regulations on career succession planning and related issues under the Employment Equity Act. We have huge labor relations regulation, and effectively the whole ambit of human resources is now regulated. The only outstanding area, in a sense, was the whole issue of remuneration, where outside of bargaining councils and sectoral determinations, remuneration was really based on a willing buyer, willing seller principle. And of course, that has now effectively been changed with the amendment to the Labour Relations Amendment Act, as well as the Employment Equity Act. The second issue I want to raise as a preliminary point is that the issue of remuneration is a very emotional issue. You know, I've very seldom come across people who believe they're overpaid. So the regulation of this particular aspect of human capital and human resources lends itself to a potential emotional engagement where employees are very eager potentially to compare their earnings to those of their colleagues. And then the final point I want to make, just very, very importantly to bear in mind right at the outset, colleagues, is if I cast my mind back to 1998, when the Employment Equity Act was promulgated, and for the first time we were told that we could not discriminate unfairly on the basis of race, gender, disability, age, coming from Bloemfontein or coming from anywhere else for that matter, we were all very concerned because the very questions that are being addressed find themselves on the front of any application form. And we were worried that job applicants would effectively keep us busy at the CCMA and the labour courts substantial amounts of time, but that has not happened. And I suggest to you today that the reason that that hasn't happened is because companies responded to that by having very, very detailed policies, procedures, and practices that drove their recruitment and selection strategies. And I must tell you now that both the Labour Relations Act and the Employment Equity Act, first and foremost, require you to have a very, very well documented, consistently applied, and rational remuneration policy. And I must be honest, I found in many organizations that that is often the policy that historically has attracted the least attention in certain organizations. Well, if we take a look at the slide that's in front of you now, the question that is posed is we've got this equal treatment provision in the Labour Relations Act, and in the Employment Equity Act we have this reference to equal pay for work of equal value, and the question fundamentally is, are they actually addressing the same thing? In other words, if you apply the principles of equal treatment under the LRA equally to the Employment Equity Act, will you be addressing the requirements of both acts simultaneously? And I would argue to a great extent that effectively, even though equal treatment is a different term to equal pay for work of equal value, my argument would be that the same principles underpin both of those in terms of ensuring fair practices. So I believe that one integrated remuneration policy and strategy would address both of those equally. Obviously, the contents might have to be adapted and the scope of application, but certainly I think that they speak to the same principles. Just while we're on that slide, quickly to unpack the equal treatment clause under the Labour Relations Act. Colleagues, you remember that the section 198 of the LRA is the area that we're looking at, and you'll recall section 198 addresses three types of employee. Firstly, TSs, temporary employment services, people on fixed-term contracts, and part-timers. And the LRA was promulgated on the 1st of January, as we all know, and as from the 1st of April, which is now passed us by a week ago, the right of equal treatment for those three categories of employees has already now kicked in since the 1st of April. I think the most important observation at this point is that the equal treatment rights under the LRA require an immediate alignment and compliance by employers in respect of their fixed-term contractors. So in other words, that right applies with immediate effect as from the 1st of April. So if you have a temporary administrator on a fixed-term contract, and that temporary administrator is working alongside a permanent administrator doing the same work or similar work, then if that temporary worker is under-remunerated by 20%, then all things being equal, you need to immediately align that individual. There's no phase-in period in respect of the LRA provisions. Obviously, as we're going to see just now, you can pay differently based on justifiable grounds, but the point is if there are no justifiable grounds for income differentials, then you have to equalize with immediate effect. On the right-hand side, you'll see the Employment Equity Act, and I've listed Section 6, which talks to the fact that you cannot discriminate on equal pay based on the prohibited grounds, race, gender, all those types of things. Section 27 of the Employment Equity Act talks to income differentials, and then of course we have the regulations which have been published. The colleagues, Casey will make available to you also the Code of Good Practice that we are busy negotiating at NEDLAC as we speak. The Code of Good Practice on equal pay for work of equal value is far down the track. It's a really useful code and provides a lot more detail in that regard. It hasn't yet been finalized, but we're happy to give that to you to really pretty much see what it's going to be used by the courts and by arbitrators in order to determine your cases in this regard. So the point I want to make on the Employment Equity Act, colleagues, is if you read Section 27 and the regulations and the Code of Good Practice, the primary difference is under the Employment Equity Act, where you're looking at employees that are permanent employees in your organization. If you come across income differentials that are not capable of justification, you have a reasonable time to remedy that. In the same way, you've got employment equity targets for black, female, and disabled employees over 1 to 5 years to try and make reasonable progress. If, for example, you find that certain staff performing the same or similar jobs are underpaid, you don't have to remedy it immediately. You have a reasonable time to remedy it. So that is a significant strategic difference under the Employment Equity Act when compared to the LRA. The final comment before I move off the slide, colleagues, is that the Labour Relations Act specifically targets vulnerable people. And as you know by now, vulnerable has been defined as anyone who's not permanent and who earns below 205,000 Rand per annum and is employed on a fixed-term contract or on a part-time basis for more than 3 months. So the Labour Relations Act deems those individuals, those categories of employment to be vulnerable, and that's why there's an immediate alignment required. Whereas if you're permanent on the right-hand side, apparently you're not vulnerable if you're permanent, and therefore the employer has got a reasonable time to eliminate inequalities. The 205,000 Rand threshold, which is the BCA threshold, I can tell you is also currently under review at the Department of Labour. That's a threshold which is reviewed regularly, and they're looking at increasing that very shortly. They're currently getting submissions. The scary thing is that they define a vulnerable employee as someone who currently earns 17,000 Rand a month or less. I'm not sure that that is an accurate reflection of vulnerability. Around 80% of all the people employed in South Africa earn below 205,000 K. So that means that suddenly 80% of our entire workforce are vulnerable. which is problematic to me in an environment where you have very high unemployment. So, colleagues, moving to the next slide, if we unpack the Labour Relations Act, remember the LRA talks to vulnerable employees, and vulnerability, as I indicated, is determined by individuals who earn less than 205k per annum and who are placed on fixed-term contracts for more than 3 months. So on your slide, it's those individuals in the orange quadrant. Now, we know that one of the primary rights that arise for those employees is the right to equal treatment under the Labour Relations Act. Of course, access to organizational rights and the deeming relationship, if labour brokers are involved, also occur there. But today the focus, of course, is around equal treatment. And what we have seen in the marketplace, interestingly, since the 1st of April, the AdCorp group placed 90,000 plus people a day across all industries and sectors, and we've been monitoring this. And of course, what we are finding, especially in unionized environments, is trade unions are now largely going to companies and stating that employees have the right to equal treatment if they've been on FTCs for more than 3 months. Also, they're adding to that right allegations that people should go permanent. But what I can tell you is that it's an ideal opportunity, obviously, for trade unions to leverage this right. So employers need to know exactly where they stand in that regard. So if we take a look at the Labour Relations Act specifically, there are a number of questions that arise, colleagues. So, for example, when we talk about equal treatment, what is the extent of equal treatment? Does it mean that your salary, your basic salary, has to be aligned? Does it mean that your salary plus your benefits? Does it include access to vacancies? Well, let's take a look at Section 198A. This section refers to temporary employment services that are providing clients with staff for more than 3 months. And as we've read before, the employee is deemed to be an employee of the client. That doesn't mean that the labour broker is not an employer, but what it means is a co-employment relationship arises. But very importantly for today's session, it says that the employees of the labour broker or the TS must be treated on the whole not less favorably than an employee of the client performing the same or similar work unless there is a justifiable reason. So if we just quickly extrapolate some principles from that. The first thing, colleagues, is the clause says that they must be treated on the whole not less favorably. Please note, they don't say that the temporary workers must be on the same pension fund, the same provident fund, the same medical aid, the same group life cover, the same funeral scheme, or anything of the exact same type as those that the client's employees are on. What it is telling you, though, is all things being equal, when you look at a cost-to-company comparison, those employees should be on the whole on an equal footing. And that's why there's a problem with people who say that after 3 months temporary workers become permanent, because the Act doesn't say permanent. The Act says they could have an indefinite expectation. And the reason they used indefinite and not permanent is specifically that if they wrote the word permanent, it would mean that after 3 months the employees would have to resign from the labour broker, be re-employed by the client, go onto all the client's funds, and that was clearly never the intention, because it's not a direct comparison, but it's on the whole comparison. The other issue is that the temporary employment service individual can compare themselves to an employee of the client performing the same or similar work. So again, we've got to be very careful there, colleagues, because you could have 2 forklift drivers in a warehouse, one through a temporary employment service and one who's permanent, with a significantly higher earnings by the permanent employee. But if you actually do a profile of that position, you find the permanent forklift driver has got extended responsibilities in terms of accessing stock control systems, in terms of quality assuring products coming in and leaving the warehouse, whereas the labor broker forklift driver might very well just be doing that, driving the forklift. So it's really important, if you want to address this properly, to have an accurate job profiling system to ensure that you are comparing apples with apples and not apples with some other fruit that is out there. And then, of course, the third issue to take home is that it doesn't say you must pay all the forklift drivers the same. There can be justifiable reasons for differential treatment, and we'll come back to that in a second. So that was the labor broking provision in 198. Let's look at what they talk about FTCs, and this is where companies employ their own fixed-term contractors directly. And you can read through that again. It talks about an employee employed on a fixed-term contract for longer than 3 months, and then again must be treated on the whole not less favorably. So if you employ your own FTCs, after 3 months, they don't have to go on your pension fund, your medical aid. Many of those funds don't allow them to join if they're temps or if they haven't worked there for a period of time. But once again, you're going to have to gross their salaries up and to see that on the whole they're not worse off. Again, the comparison is performing same or similar work, and again, justifiable reasons for differential treatment. I think an important observation at this point is that there's no benefit in using a labor broker or not using a labor broker. The same rules apply irrespective of how you access your fixed-term contractors. So anyone who believes that by not using a TES or labor broker that they're winning some points is absolutely mistaken, because exactly the same provisions apply to both contexts. To the right of that slide, we will see the definition of remuneration. Now, equal treatment, I must first tell you, is a broad concept. They didn't call it equal pay, they call it equal treatment. So just for purposes of illustration, clearly remuneration is the first port of call, because that's where your potential greatest liability exists. And we know already that remuneration at law, and certainly in the LRA, means payment in money or in kind, or both in money and kind, made or owing to a person in return for them working. So the first thing we have to understand is when we compare remuneration of FTCs or TS employees versus permanent counterparts, we are not just comparing the basic rate. We've got to look at it from a cost to company basis, which includes benefits and those types of matters. The other thing is the LRA is very clear, colleagues, in that it specifically gives mention to fixed-term contractors who've been employed for more than 3 months having an automatic legal right to apply for vacancies in the organization and to access training on an equal footing within that organization. So when we talk about equal treatment, it's really a broader concept rather than a narrower concept, and if there was any doubt, it's a cost to company comparison. Your recruitment policies may very well have to be amended to extend the right of application of internal vacancies to FTCs or labor broking employees, and your training and development policies and procedures likewise may very well have to be modified to make provision for that. What I haven't put on here are other policies such as disciplinary and grievance policies, which should be aligned with those of your labor brokers, or rather they should align theirs to yours. Performance management policies and practices, and other big ticket policies. So the bottom line is there should be a convergence of practices and consistent practices in that particular context. So, ladies and gentlemen, that is the Labor Relations Act component of equal treatment. I want to change gear now and move to the Employment Equity Act, just to try and look for an immediate comparison. So under the Employment Equity Act, we firstly see that, and the heading of the slide, my apologies, should actually read from the horse's mouth, Employment Equity Act, and that's my fault. I didn't edit it properly. But we are definitely here in the Employment Equity Act space, And specifically, we see the Employment Equity Act in Section 6 talks about a difference in the terms and conditions of employment. So if we just stop there, again, we see that when we talk about equal pay for work of equal value, we are talking about cost to company. We are talking about payment in money or in kind. So it's the all-encompassing terms and conditions of employment. Then it says between employees of the same employer. So if I work for company A and we have 500 permanent staff in our employ, that means that we are all employees of the same employer, performing the same or substantially the same work or work of equal value. Now, colleagues, this is the first area of divergence from the LRA that I've noted. The first area talks now not about comparing a forklift driver with another forklift driver as we've seen under the LRA, but under the Employment Equity Act, they make it a broad basis for comparison. So they're not saying comparing jobs of employees performing the same work and leave it at that. No, they extend it to talk about substantially the same work. And then they take it even further and they say, or work of equal value. Now what's interesting is if we look at the Canadian law in this regard and law from other jurisdictions, you have cases where a nurse, for example, has compared her or his remuneration to that of an artisan fitter. And one would say that there's no logical relationship between those two occupations. How can they compare themselves to each other? The simple answer, colleagues, is in the wording work of equal value. Let's say, for argument's sake, that this company uses a Patterson grading system. You may find that nurses are on the same Patterson grade as artisan fitters. And even though the occupations by job title are unrelated, the value attributed to those positions are comparable. And if the nurses as a cluster are earning significantly less than the artisans, and nurses are predominantly female and artisans, for argument's sake, predominantly male, the first ground of claim could be unfair discrimination. And certainly, if not that, we see the very last line talks about any arbitrary ground. So it's really important, ladies and gentlemen, when you are looking at the Employment Equity Act applying to your permanent staff or people that are generally noted on your EEA2, it's very important to make sure that you take a broad view of equal value. A grading system becomes absolutely indispensable in this whole mix. Let's unpack the Employment Equity Act a bit more, and I'm not going to belabor this. I'm just going to touch on one or two aspects of the code of good practice on equal pay for work of equal value. The first issue is, in the second bullet point, says we want to eliminate unfair discrimination. So by the same token, it is absolutely fine to discriminate as long as you're doing so fairly. And that's established law in our country already. The third point is a very important one because it again reiterates that when you're comparing different job types or different employees, it's not limited to the same jobs being compared, but it's a broad, same or substantially the same work within the same employer. I was asked the question recently, well, what if my company only has one nurse because it's on a mine out in Kuruman, and that nurse says she's underpaid relative to another mine in Sishen? Can that nurse compare her income to the nurse in another adjoining mining community? And the answer to that is no, she cannot compare herself to a nurse in another mining community or a nurse in any other community, because the Act is clear. It talks about employees of the same employer. Okay, so this isn't carte blanche to go and compare yourself to every man and his dog working for some remote organization. It's got to do with the point of reference is that particular employer. The next slide is really important, colleagues, because it provides you with a methodology or the framework, the broad strokes of a methodology. So if you're sitting here today and say, well, John, how do we start addressing this in our organization? The code is very clear. The first step is to ask, are the jobs being compared the same? So if an employee raises a grievance and alleges that they're being discriminated on an arbitrary ground relative to a colleague of theirs, the methodology is quite simple. Is their job the same or substantially the same or of equal value to the job that they are being compared to? Of course, in the absence of some form of grading system, you're first going to have to go and profile those jobs, attach them to some form of grading before you can respond to that. But the principle is clear. Are you comparing jobs of equal value? If the answer is yes, they are of equal value, the next question is, well, are the terms really different? You know, is there really a material difference in terms and conditions? And I don't believe it's an exact science, colleagues. I don't think the judge is going to, you know, take offense if there's a few percentage points difference and, you know, whatever the case may be. They're going to look for a particular arbitrary or prohibited ground that's driving material differences. We know labor law is based on a balance of probabilities. Not everyone's going to sit on exactly the same linear comparison. But if there is a material difference in terms and conditions, the third question is the determining factor. The third question then is, can these differences be justified on fair and rational grounds? Now, the reason I'm going to ask KC to load that Code of Good Practice on their website or to distribute it to you is because you'll be very, very pleased with the list of grounds that would be deemed to be fair and rational that have found their way into the code. Even grounds such as geographical location. So I come from KZN. I don't know why, but we get underpaid in KZN relative to Gauteng, where some of the colleagues work. You know, the Western Cape have their own regime in terms of wages and wage inflation and levels. So geographical differences are noted. Even differences, for example, if someone was demoted in the past, but you haven't reduced their salary when you demoted them, that is a justifiable reason for them earning more than their colleagues. Other differences would include performance, the normal stuff, performance, length of service, merit, equality, quantity of work, experience, qualifications, a whole range of grounds, colleagues. But the point you've got to bear in mind here, as I said at the outset, you've got to define what it must look like in your company. In a manner of speaking, you've got to bake a remuneration cake for your company. You've got to say, what is our business strategy? What is our culture? What is our value system? Do we recognize performance? Do we want to encourage performance-based remuneration? Do we want to encourage long tenure and loyalty? Do we want to encourage people to learn in our organization? And then you need to take those three ingredients, and then you've got to mix them together, and you've got to bake a cake that defines that remuneration strategy in your company. And then you've got to ensure that new employees, existing employees, and whoever else are aligned to those particular principles going forward. I remember in my first employment with a petrochemical company, we weren't allowed to employ anyone unless we first did a salarisvergelyking. If you come from Bloemfontein, you'll understand that. If you don't, well, it means salary comparison. So we weren't allowed to appoint anyone unless we plotted them on a curve which looked at experience, qualification, performance, and then we made the offer of employment to ensure there was a fair and rational ground to offer them that particular income. And I think that type of practice is going to have to become an integral part of any remuneration policy. The last point on this particular slide talks to the fact that steps have to be taken to progressively reduce differentials. So once again, the Employment Equity Act allows you to put in place a strategy for progressive elimination of income differentials. Rome wasn't built in a day. You've got a bit of time on hand to do this. The problem I have here, ladies and gentlemen, is the Employment Equity Amendment Act came into effect already on the 1st of August last year. I wonder if I walked into your companies now and I asked for your employment equity plans, I'm sure you will have a great strategy around race, gender, disability, per occupational level. You'll have barriers and affirmative action measures, and you'll have great things around that. But I wonder if I would find a plan that addresses your plan of action around progressively identifying and reducing income differentials. And I'd suggest to you, if you haven't done that, that you're open to being fined 2% of your annual turnover, which is not a small amount of money. So what is the approach that should be taken in organizations around these two acts, the LRA and the Employment Equity Act? Well, the first thing, colleagues, in the Labor Relations Act is we are fortunate that the Act does not attribute equal treatment rights to certain types of people. Those people are learnerships. Employees on learnerships are regulated by a sectoral determination, and if there are 18.2 learners on learnerships and you've employed them, you needn't pay them any more than what the sectoral determination requires. They cannot compare themselves to their permanent counterparts who are in those positions. The second exclusion from the right to equal treatment are employees who work for less than 3 months. So your seasonal, project, very short-term employees, those employees will not be entitled to equal treatment rights. Of course, if you earn above 205,000 Rand per annum, you're not deemed to be vulnerable, at least for now, until it is increased, and there's no immediate right to any remedial action. And then a very interesting area is absenteeism replacement. Any person replacing someone on maternity leave, sick leave, family responsibility leave, and any other type of leave, study leave, any replacement of a legitimate absentee is not entitled to equal treatment. So what we find companies doing, ladies and gentlemen, is we find companies significantly reviewing their staffing and their take-on methodologies. So rather than bringing a call center agent in immediately at 15,000 Rand per month, many companies are now looking at a career progression where they'll first go through an incubation period, followed by a learnership, followed by a statutory period during which they've got to comply with certain Financial Services Board requirements, and then ultimately graduating through to being a particular fully fledged call center agent. It helps you benefit from learnership tax breaks, the employment tax incentive, certain BEE drivers. So many companies are revisiting the manner in which they employ people. Even absenteeism replacement, we see companies with 5 to 8% daily absenteeism having a pool of multi-skilled employees who are then dispatched into various sections of the business as absenteeism arises. And of course, those employees would not have rights to equal treatment. Once you've exhausted those opportunities, because the reality is wage inflation is a very real challenge, and we also see significant increases in human capital costs with the BE codes, for example, are increasing it to 6% of payroll in terms of skill spent on black employees for training under the BE code. So we cannot, as business people, just allow wage inflation to run away with us. We need maximum return on inflation. The next thing the Labor Relations Act then does, it says, well, you can pay people differently based on justifiable factors. And I've listed the justifiable factors there. They are listed in the Labor Relations Act. And again, as is the case with the Employment Equity Act, companies need to hang their hat on 1, 2, 3, or a combination of these factors. I came out of a meeting this morning with a warehousing and distribution company where tenure and experience was a key differentiator in terms of their remuneration curve. In other organizations, your call center environments where performance is very, very well and closely monitored from a quantitative and a qualitative point of view, performance is the primary driver. So I think the fear that many people have around equal pay for work of equal value is demystified. Someone once said to me, if you're fearful, the fight or flight syndrome kicks in. So all the blood drains from your head into your major muscle groupings. So if you make decisions when you're fearful, you're effectively a moron because your brain doesn't have any blood assisting you to make the right decision. So I really think companies need to relax. They need to take a calculated view of this and then have to move forwards and meet your business strategy. Don't let labor law underpin your business strategy. Your business strategy must dictate what you do in labor law. Too many people are fearful around these amendments, and they're undermining and prejudicing the sustainability of their businesses going forwards. The next slide just gives you an example of a policy position on remuneration. So here was an organization that we were engaging with. You'll see in the left-hand side, the y-axis, right at the bottom, there are the unconditional exclusions from equal pay rights. So we've been through that. People on learnerships, etc., do not have the right to equal pay. Then just above that, you have your conditional factors. So seniority, experience, performance, length of service. Then you can look at introducing trainees, grade 1, grade 2, grade 3, and have a progression of a career path, as opposed to really not applying your mind, just having a one-size-fits-all and wage inflation kicks in from day one. So there are some very innovative models, and in fact many clients who've adopted these processes have saved money going forward. The question is, can you reduce the earnings of current employees? And the answer, of course, is no, you can't. So even if you introduce a new model similar to this, if people in grade 3 are earning above what they should, you can't go and reduce their remuneration. But what you can do is all the new individuals that come in obviously would be appointed against the new dispensation, and you would have to have taken this new dispensation through your Employment Equity Committee because it does affect your occupational levels and your grading. Colleagues, I'm not going to spend too much time, my apologies, too much time on the next slide. Casey did touch on some of the other staffing models and solutions that are being looked at. The reality is we are living in a highly competitive environment where things are very uncertain, and of course there's not a hell of a lot of case law or any case law around this in South Africa at present. So some organizations have looked for other models to try and address threats around equal pay and equal treatment and all that kind of stuff. So one of the obvious things right at the top is some companies have opted for independent contracting arrangements. Simple example of that is your cleaning services, your IT services, your call center outsourcing services, where your provider of that service is solely liable for equal treatment, whereas obviously with a TES environment, you're jointly liable with the TES. But if you can possibly convert legitimate staffing solutions into independent contracting arrangements, I think that's a very good opportunity to pursue. The second one is full category outsource. This is where entire categories in companies, so in warehousing and distribution, they outsource all their pickers, packers, forklift drivers, reach truck drivers. There's no permanent employee in that mix. So you are able to have a very standardized dispensation in the full category outsource. Another example in that space would be the managed service provider, and Casey touched on that. It's literally where companies that have multiple providers of staffing and other services, they have someone who comes in between. They get one invoice from the MSP. The MSP's got good BE credentials, so it supports preferential procurement, and the MSP then drives consistency and standardization amongst the staffing providers that are below the MSP. Very important from a governance point of view, as well as a systems and a liability regulatory point of view. Other companies' colleagues are fixated, unfortunately, on permanent employment. I don't know what it is, but some companies just say, well, you know what, we want to employ all our people permanently and directly. Well, the simple solution to that is you can be assisted in that regard as well. The employment relationship could then be with you directly, but a temporary employment service like Quest could still do exactly what they're doing at present. The only difference being they're not the employer, you the employer, but they would still recruit, select, discipline, performance manage, payroll, and do whatever else they do. That means you would not have to staff up and capacitate that section of the business yourself, but you could, all your non-standard employees could then be facilitated by your traditional TS. So, ladies and gentlemen, that effectively is just a very quick overview of some of the thinking out in the marketplace and international trends as well we see following that. I think the final slide before I hand back to Casey to possibly assist me in taking some questions is how can we assist you in this regard? Now, ladies and gentlemen, the reality is there is no one-size-fits-all solution. What's been very evident to me is that the merits of each company will dictate the outcome. Each company has a different business strategy, a different appetite for risk, a different employee value proposition, and I'll see that the next webinar is on employee value propositions, and Casey will talk to you more about that later on. But the reality is there is no one-size-fits-all, but what we do have, I can assure you in assisting you, is we have the knowledge and the tools to apply in your environment to come up with an appropriate solution. We have got systems that drive job profiling. We've got a Pathfinder system and other systems which already has a library of thousands and thousands of jobs across industries and sectors which allow you to access those job profiles, tick off what applies in your context, add what additional factors that may apply, and we are able to do very detailed job profiling from the point of view of personality requirements, EQ, cognitive ability, knowledge, skills, and all those types of things. Once we've done the profiling, we can look at career pathing and succession and put job families together, and then obviously we can look at some form of job grading system. The wonderful thing is that the law does not require you to have a branded Piromni's, Hay, Patterson, you name it, system. As long as you come up with a system that is consistent and fair, you can actually design your own particular system, and we can help you with that. We can also run the numbers and come up with income differentials. It's quite amazing in certain companies you'll find contract manager being a job title, and if you look at the highest earning contract manager and the lowest, there's sometimes a 300% income differential, but they're all called contract managers. So we'd be able to advise on how to use legitimate responsibility, decision-making authority, environment, all those things to try and help you structure subcategories within scales of employment. We can come up with equalization models, and then obviously we can look at remedial options. We can help you put together strategies to either under the Employment Equity Act to help you with a progressive strategy to eliminate unjustifiable income differentials, and we can help you in the LRA space if there is an immediate requirement to align. We can also help you with the various models in that regard.
Ladies and gentlemen, we have come to the end of this presentation in terms of what John Botha was giving you. I've been alerted that at the beginning some of you did not get my name in full, so my name is Casey Makhubele. We had asked for people to type in their questions. If you still have a question, please type it in so that we may be able to answer that question for you. If there are no questions, we will obviously get to the end of the webinar. There is a question that has already been asked, and I'm going to ask John to answer. It's been asked by Elgina Ndlovu, and the first question is, What is the Act saying around the entry into the organization? People often join organization on different scales of payments, often above the salary scales of the organization they are joining. John.
Thank you, Casey. I think the first thing is, as I mentioned, companies first need to make sure they've got a sound remuneration policy, which includes your pay grades and salary scales per grade. Once you have that, if people fall above or below those scales, below the minimum or above the maximum, whether it's a legacy issue or just a mistake in any event, remember that would fall generally under the auspices of the Employment Equity Act, and you would have an opportunity to provide a remedial plan of action over a period of time. So the nice thing is, even though you are actually in not complying, if you don't have people within those salary scales, you're not going to get into trouble immediately as long as you can show you've got a plan of action going forward to try and bring them in line. That plan of action may incorporate different strategies. It might mean that the annual increases are a percentage or two lower than their colleagues until such time they fall within that salary band. There are a whole range of opportunities. The other thing also, just to bear in mind, that the Employment Equity Act applies equally to public and private organizations. So government organizations as well as private sector organizations all are subject to the Employment Equity Act. The only people excluded, of course, KC, are soldiers and spies. So it would be terrible if they stop working because of, they believe they're underpaid. But other than that, all of us have that right.
Thank you, John. The other question that I have is, you've started touching on it. It also comes from City of Johannesburg. Different organizations do not have the same salary scale, being in whether it's private or public. How is the Act addressing this?
Casey, yeah, look, as I mentioned, the reality is the Employment Equity Act says that employees can only compare themselves to their own employer. So employees cannot compare the earnings of other employees of other employers. So how does it affect public or private? Well, it excludes you from having the right to compare to other organizations.
All right. I've got another question from Bianca Perry. To an extent on one of the previous questions, how does pay get determined according to the Act when entering a position due to the previous employees leaving, that is replacing them in the position? Does salary get determined by the previous employee's current salary, or is there a pay grade or analysis that determines this?
Yeah, well, again, what I need to say at the outset is, going forward, you're going to need a very, very clear pay scale and remuneration strategy. So I would like to think that already companies have got their different occupational levels, their job types within those levels, and certain pay scales attached to that. If a person leaves and they're earning, say, 20,000 Rand a month, and they appoint a new employee at 16,000 Rand per month, there's no problem with that on the face of it, as long as the person earning the 16,000 Rand has been placed at 16,000 Rand based on the factors that that company has chosen to direct your levels of remuneration. So if the company have paid that person 16,000 Rand a month because he or she has got less years of experience in the industry, a lower qualification, well, then it would be justified. So I think you've got to be very careful that if someone leaves at 20,000, you're appointing them with 16, you're replacing them with someone at 16, you've got to be careful that that is a justifiable decrease, because if the person coming in, for argument's sake, is a woman, and the person who's exiting that job was a male, the woman might very well claim that because she's a woman, she's being undervalued purely as a result of her gender. So again, the bottom line is you need to have a remuneration policy and a structure and a framework that allows you to make informed decisions when appointing people.
Thank you, John. I do believe that there may be further questions. So ladies and gentlemen, we would like to come to the conclusion of this webinar. If you still have questions that you want to ask us or you want to ask John, you're most welcome to send your questions or queries through to the email address that I'm going to provide for you in the last slide. Before we do that, I just want to let you know, as John has alluded to this, our next webinar, which is happening on the 28th of May, the 28th of May is the Value of Employee Value Proposition, the EVP, for non-permanent workforce. This is our finding that we would like to share with you guys. It refers to the employees of the TES as well as the FTC, in other words, the people that you directly employ. It will be a wonderful presentation presented by Carolyn Blanding. So ladies and gentlemen, we look forward to hosting you on that particular day. And in terms of what I indicated earlier on, we would like to thank you very much for attending this conference and this webinar. We have had about 101 people that were attending today's webinar. We do know that some of the organizations that are represented here are broadcasting this to many more executives in their environment. The email address is provided on insights@quest.co.za. If you still have any particular question that you would like to ask, as well as if you are interested in getting a consultation services from John so that he can assist you with some of the things that he has mentioned, you're most welcome to send us, and we will provide you, we will come to you and assist you in terms of your strategy to deal with the topic that we have discussed today. Ladies and gentlemen, thank you very much for attending the webinar.